Thank you very much. My name is Kara Maciel. I'm founding partner of the firm Kahn Maciel Carey, and I am thrilled to have a webinar and a chat with EEOC Commissioner Keith Sonderling, Artificial Intelligence in the Workforce in 2020 and Beyond. Our small little boutique firm was founded 8 years ago, and we focus our practice on labor and employment law and workplace safety. As I mentioned, I'm founding partner. Attending with me in this webinar is my partner, Jordan Schwartz. Jordan, you want to briefly introduce yourself?
Sure, thanks, Kara. It's a pleasure to join all of you. I've been Kara's partner since the founding of this firm in 2014. And we practice every single facet of labor and employment law and are just thrilled to have Commissioner Sonderling with us for this exciting event today.
A little background about Commissioner Sonderling. Keith Sonderling was confirmed by the US Senate with a bipartisan vote to be Commissioner of the US Equal Employment Opportunity Commission in 2020. As many of you may know, the EEOC is the federal agency that's responsible for enforcing federal laws that make it illegal to discriminate against either a job applicant or an employee because of the person's race, color, religion, sex, national origin, age, disability, or genetic information. Prior to his confirmation to the EEOC, Commissioner Sonderling served as the acting and deputy administrator of the Wage and Hour Division of the Department of Labor. Before joining the Department of Labor in 2017, Commissioner Sonderling practiced labor and employment law in Florida. Since joining the EEOC, one of Commissioner Sonderling's highest priorities is ensuring that artificial intelligence and workplace technologies are designed and deployed consistent with long-standing civil rights laws. Commissioner Sonderling has published numerous articles on the benefits and potential harms of using artificial intelligence-based technology in the workplace and speaks globally on these emerging issues. And without further ado, it is my privilege and honor to welcome Commissioner Sonderling, and looking forward to a really exciting program today.
Well, thank you, Kara and Jordan. It's a really pleasure to be with everyone today. So I'm going to give an overview of this topic, and then we'll open it up to some questions. But again, very grateful for the opportunity. So what am I even talking about? So when you hear about artificial intelligence and robots in the workplace, most conversations tend to drift towards a dystopian future of robots displacing humans. The World Economic Forum predicts in the next 4 years, 85 million jobs may be displaced by AI. A 2019 Brookings Institute study examined the overlap between the text of AI patents and the text of job descriptions from the Department of Labor database. That study found that of the 769 job categories included by the Department of Labor, 740 of them had at least some near-term risk of automation. We've already seen artificial intelligence allegedly outperform doctors, lawyers, and journalists. And by 2025, some predict that AI will be so pervasive that machines and humans will be working the same number of hours. PwC recently released a study predicting that 38% of all US jobs will be automated away by new tools such as artificial intelligence. And it might be cheap. Research has shown that with robotic process automation, businesses are building bots that cost $10,000 a year while displacing 2 to 4 humans. USA Today confirmed this when they recently had a headline story titled, "Robot Orders by Companies Surge as Labor Shortage Lingers." So most conversations about AI and machine learning in the workplace are about a future like this. But that's not what I'm talking about today. I'm here to talk about the present because from a standpoint of AI and workplace anti-discrimination law, the future is now. The pandemic has transformed the way we work, but critically to this topic, it accelerated the rate at which employers are adopting AI to manage their workforces. AI makes dizzying amounts of data legible for businesses, culling and correlating information on a massive scale to make workforce-related predictions. And that's translating into huge business. HR tech spending tripled to nearly $17 billion in 2021. And according to recent projections, HR technologies will drive the value of HR management market at a compound rate of 12% for the next 7 years. As you all know, virtual recruiting is playing an outsized role in shaping the broader teleworkforce, and studies suggest that it will stay that way. Job interviews over Zoom have become commonplace since the pandemic. And 70% of talent professionals reported that they believe that virtual recruiting is the norm long after the pandemic is over. Employers, especially those who need to hire rapidly and in large numbers, are turning to AI-driven technologies such as resume screening programs, automated interviews, mobile hiring apps to rebuild their workforces. To the millions of employees who were displaced by the COVID-19 pandemic, these technologies, whether you realize it or not, were a fast track back into the workplace. And to the businesses whose doors were shuttered by the pandemic, they offered an efficient path back to profitability. This turn to AI-driven HR technologies did not happen overnight. The reason I'm talking about the AI and the reason the EEOC is looking at AI is that AI has already been involved in the decision-making stage of the job life cycle, of every part of the job life cycle for years. AI writes job descriptions, screens resumes, chats with applicants, conducts job interviews, and then predicts if an employee will accept an offer, and in some cases predicts how that employee will interact with their new coworker. It identifies employees' current skills and potential skills, tracks productivity, assesses workers, and picks who gets those career-changing upskilling and reskilling opportunities. Nowadays, if an employee falls short of expectations, an AI algorithm may even send them a message saying, "You're fired." In short, AI is making nearly all the types of decisions once made by HR personnel. This is not necessarily a bad thing. It's not necessarily a good thing. At the risk of sounding like a lawyer, which I am, it all depends. Carefully designed and properly used, I believe that AI has the potential to advance diversity, inclusion, and accessibility in the workplace by mitigating the risk of unlawful discrimination. You all know, whether you're business owners, lawyers, HR professionals, you all know that employment decisions are vulnerable to bias on the part of hiring professionals, which is part of the reasons the EEOC exists. For example, one study showed that hiring managers are more likely to favor resumes featuring male names over female names, even though the resumes are otherwise identical. Another study showed that African Americans and Asian Americans who whiten their resumes, that's by deleting references to their race, received more callbacks than identical applicants that included racial references. Oftentimes, HR professionals do not become aware of the discriminatory conduct until it is too late. But AI can help eliminate bias from the earliest stages of the hiring process. For example, an AI-enabled resume screening program can be taught to disregard variables that have no bearing on job performance, such as an applicant's name. An applicant's name may signal correctly or incorrectly variables that usually have nothing to do with that applicant's job qualifications. Think about it, such as their sex, national origin, religion, or even their race. Likewise, an AI-enabled program that conducts preliminary screening interviews can be engineered to disregard factors such as age, sex, race, disability, and pregnancy. It can even disregard variables that might merely suggest a candidate's membership in a protected class, including foreign or regional accents and speech impairments. And in some cases, replacing an interviewer with a bot eliminates the opportunity for intentional discrimination at the screening phase of the hiring process. It is not unheard for an interviewer to meet a highly qualified candidate who is visibly pregnant, disabled, or religiously observant and think to themselves, this person is going to cost me. Accommodations will cost me. Healthcare will cost me. Leave will cost me. This candidate just isn't worth it, so I will go with someone else with similar skills who are not going to make those requests. Obviously, this example is highly illegal, but it's one of many instances that AI might mitigate. At the same time, poorly designed and carelessly implemented, AI can discriminate on a scale and magnitude far greater than any individual HR professional. That's because the prediction AI makes about specific applicants are only as sound as the training data on which the algorithms rely. For example, an algorithm that relies solely on the characteristics of a company's current workforce to model the attributes of the ideal job applicant may unintentionally replicate the status quo. For instance, if the current workforce is made up primarily of employees of one race, one gender, or one age group, the algorithm may automatically screen out applicants who do not share those same characteristics. Case in point, and probably one of the most egregious examples, employing this metric, a resume screening company found that the most likely predictors of success at one particular firm were being named Jared and having played high school lacrosse. So as an attorney, I've dedicated my career to labor and employment law. I want to see AI reach its full potential in the workplace. And as an EEOC commissioner, I'm committed to helping workers and employers understand their rights and obligations when it comes to these technologies. That said, I'm going to address some of these issues today. First, I'm going to explain how the decades-old law the EEOC administers and enforces relate to rapidly developing AI technologies. Then I'll flag some of the potential risks associated with using AI at various stages. And then I will discuss some suggestions, and we'll talk about it more in the questions and answer, on how you can best select and deploy AI in the workplace. As you heard, the EEOC's mission is to prevent and remedy unlawful employment discrimination and advance equal opportunity for all in the workplace. Many of the laws we enforce predate by over half a century the AI technologies I'm discussing. Nevertheless, federal anti-discrimination law is as applicable to employers who use AI to make employment decisions as they are to employers who rely exclusively on HR professionals. By way of reminder, the EEOC enforces Title VII, the Civil Rights Act, the Pregnancy Discrimination Act, the Equal Pay Act, the AIDS Discrimination in Employment Act, the Americans with Disabilities Act, and the Genetic Information Non-Discrimination Act. These laws broadly protect an applicant or an employee from discrimination based upon their race, color, religion, sex, sexual orientation, gender identity, pregnancy, national origin, age, disability, or generic information. The laws apply to all types of work situations, including hiring, firing, promotions, training, wages, benefits, and also prevents retaliation and harassment. So in short, they apply to every type of employment decision that employers are using AI to make. So without giving you the full-blown labor, the law school lesson on labor and employment, just think generally there are two theories of discrimination under our laws. And to keep it simple, think intentional or unintentional, known as disparate treatment or disparate impact. So under disparate treatment, an employer deliberately treats some people less favorably than others because of their membership in a protected class. For example, their race, sex, or religion. So for the easiest example of disparate treatment, if an employer were just to throw away resumes of all applicants of one race, that employer would be engaging in intentional discrimination. Disparate impact discrimination exists when an employment practice that is neutral on its face has an adverse impact of members of a protected class. Another textbook example of this, let's say a company wants to increase the likelihood that its employees will arrive at work on time every day. So it decides to only hire people who live in 2 zip codes, both of them next to the office. If these zip codes, though, are populated predominantly by members of one race, the policy may have the effect of excluding members of other races from job opportunities, even though the intent of the policy was just to make sure that no one was late for work. So while a disparate treatment claim requires a showing of discriminatory intent, disparate impact does not. Employers are generally equally liable for discrimination, whether or not they intended to discriminate. And this is absolutely critical for all of you to bear in mind as companies start going all in on artificial intelligence and other HR technologies. Carefully designed AI can mask for race, gender, age, disability, and other characteristics. It can mask for proxy terms, like the example I told you earlier, people's names, the names of sports teams, or someone's graduation date. It can help employers take a skills-based approach to hiring. It can offset the well-documented confidence gap that leads women to underreport their abilities on resumes and men to overstate theirs. It can identify a candidate's adjacent skills, and it can identify candidates for those upskilling opportunities. So in short, AI can identify candidates based not only on their merit, but on their potential, all while stripping out human bias. But at the same time, AI can replicate and amplify existing bias when it isn't properly designed. So now that you understand the basic requirements of the law, let's actually apply this to AI. An AI-driven resume screening tool tested by Amazon between 2015 and 2017 illustrates this well. And the legend there goes that programmers fed the algorithm a data set consisting of resumes belonging to Amazon's current employees, along with resumes that had been submitted to the firm in the prior 10 years. Using machine learning, the program was able to identify patterns in the historic data set and then use those patterns to rate new applicants on a scale of 1 to 5 based on their resumes. However, because the vast majority of resumes in the data set belong to men, the program began automatically downgrading resumes with certain word combinations, such as women's sports teams, women's clubs, and the names of women's colleges. This was not proof of a misogynistic intent on the part of the AI. It was a function of the data fed to the AI in the first place. So when it comes to AI, legal scholars, software engineers, and vendors tend to focus on disparate impact discrimination like this one. However, claims of AI can easily and do fall under the umbrella of that disparate treatment, the intentional liability. So in a recent non-EEOC class action suit, a group of plaintiffs alleged that Facebook's advertising practices, including its use of AI algorithms, violated a state anti-discrimination statute. In the court filings, the plaintiffs alleged that a number of companies restricted their employment ads to certain age groups in violation of age discrimination laws. The lawsuit alleged that employers could create a tailor-made applicant pool by simply ticking off boxes on a list of characteristics. They could check an include box next to preferred characteristics or an exclude box next to disfavored characteristics. Shortly after that complaint was filed, Facebook announced that it would be disabling a number of its advertising features until the company can conduct a full review of how exclusion targeting was being used. And as part of its settlement, Facebook pledged to establish a separate advertising portal with limited targeting options for employment ads. So allowing employers, like the matter alleged in this case, to exclude people from the applicant pool goes even further than pre-civil rights job advertisements, directly telling people of certain races, religions, and national origins not to apply. It withholds the very existence of opportunities from members of a protected class on the very basis of their membership in a protected class, leaving them unable to exercise their rights under civil rights statutes. After all, you can't sue for exclusion from a job opportunity if you don't know that job opportunity ever existed in the first place. So in an instance like this one, with just a few clicks, AI can help employers engage in disparate treatment on a scale far greater than ever before. Outside the realm of science fiction, AI has no motives or intentions of its own, at least for now. AI only has algorithms that enable it to correlate data and make predictions. And according to industry experts, this is one of the things that makes AI attractive to employers. AI's reliance on hard data creates the potential to eliminate individual discrimination by removing human bias from decision-making. And when AI is designed in a clear and explainable way, it eliminates one of the biggest challenges to effective human resources management: human tastes. At the same time, the apparently objective nature of algorithmic decision-making can result in technological bias on the part of the user. That is, an over-reliance, if not blind trust, that the robots will always get it right. In this case, the user may lose sight of the fact that AI is self-reinforcing and requires close monitoring. Employers can't adopt a set-and-forget-it approach to HR technologies because inaccurate, incomplete, or unrepresentative data will only amplify rather than minimize biased decision-making. So the example I gave you with Amazon's resume screening program is how biased inputs can yield biased outputs. But it is also an example how a vigilant employer didn't simply trust the algorithms to get things right. Amazon tested the program, evaluated its performance, and when it proved unworkable, Amazon abandoned the program without ever actually using it to make a hiring decision. But as I mentioned earlier, AI is not just being used to hire, it's being used at every stage of the employment decision-making process, beginning with the very decision to start recruiting. At the pre-hiring stage, AI has the potential to make recruiting more inclusive. For example, some programs use what's called natural language processing to help employers write job descriptions that promote greater diversity in their applicant pools. As you all know, the way a job description is written, the specific words used, and the way requirements are described can have a significant influence on who applies. So there are now programs that compare linguistic job patterns, patterns in a job description with historical applicant behavior and correlating hiring outcomes to predict which word combinations are most likely to attract applicants. In fact, an AI program claims it can predict which word combinations are most likely to attract applicants based on gender. It provides real-time feedback to employers on how likely their word choices risk alienating applicants of one gender or another, enabling the employer to aim for maximum inclusivity. AI also promises to reduce talent acquisition to a science, helping employers identify and target highly qualified candidates who may not even be actively looking for a job. In these cases, marketing firms and headhunters are replaced by algorithms that can scrape publicly available data about the individuals from browsing histories, resume databases, social media, news publications, and professional profiles to identify candidates for advertising and recruiting. Online advertising platforms do this all the time when it comes in the commercial context. That's why whatever you're looking at buying on the internet seems to be following you all over, wherever you go, popping up in ads on every website. But micro-targeting ads to an audience is one thing when you are trying to sell running shoes. It is quite another when you're advertising employment opportunities. For example, if the algorithm's training data skews heavily towards people of one race, sex, religion, or national origin, these protected characteristics may come to play an improper role in the algorithm's predictions about the members of its target audience. It may, like some of the examples I mentioned earlier, downgrade proxies for race and gender, such as the names of historically Black colleges or the names of women's sports teams. Again, not because the computer is intentionally targeting and discriminating against these people. It's because they simply were not represented in the training data. The problem is only compounded by the fact that, as with the Facebook audience exclusion example I gave you earlier, individuals may never know they were denied equal opportunity in the workplace because they were never told that a workplace opportunity existed. But some vendors are offering data-driven solutions to what are in essence data-driven problems. They train their algorithms primarily on a candidate's job skills and personal capacities. They filter out proxies for memberships in protected classes such as race, sex, national origin, or disability. They aim to build more inclusive training inputs while also validating for bias and outputs. These bias mitigation strategies can be as effective at the hiring stage as they are at the recruiting stage. And although I've discussed resume screening programs at some length, it's worth noting that poorly designed programs can readily be gamed. There's all these discussion groups online about how you could submit resumes by using white ink, which is the equivalent of invisible ink, to ensure that you're not automatically screened out. There's one UK firm that recommended to applicants to put the words Oxford and Cambridge in there and then white it out so you get by the screeners. So it doesn't just stop there. AI is being used to conduct job interviews. So here a bot presents a series of questions that the applicant answers on videos. Then again, natural language processing comes into play, evaluating the substance of a candidate's interview. A reliance on voice alone may reduce the risk of discrimination based on someone's outward appearance. But without sufficient safeguards, voice recognition may be unable to account for foreign accents or speech impairments, giving rise to potential for disparate impact claims based on national origin disability. But even if these biases could be controlled for, it might not be enough. Some interview programs also incorporate facial recognition and facial analysis technology. These facial analysis technologies purportedly identify a subject's facial expressions to make predictions about the candidate's personality and capacity for success in a particular role. So whether facial analysis can accurately predict how good a plumber or a neurosurgeon a candidate will be based on the number of times they furrow their brow is beyond the EEOC's jurisdiction. However, whether facial analysis has a disparate impact on people is squarely within our jurisdictions. As you all know, facial expressions are not universal. They vary across cultures and contexts, and for that matter, may be limited by a disability. Accordingly, a facial analysis algorithm may automatically downgrade a disproportionate number of candidates who belong to a protected class, simply because they were underrepresented in the computer's original training data. This is all assuming the computer can even recognize the applicant in the first place. Serious concerns about racial discrimination arise if an interview bot cannot even identify the face it's analyzing because the candidate has dark skin. When researchers at MIT's Gender Shades Project tested the dominant commercial gender classification algorithms, the findings were startling. Algorithms achieved an accuracy rate of over 99% in identifying light-skinned males. Now compare that 99% to the accuracy rate for identifying dark-skinned females, which ranged between 65 to 79%. The researchers attributed this disparity to the underrepresentation of dark-skinned women in the training data on which the algorithms relied. So the tensions between whether hiring technologies actually deliver on their promises and whether they effectively discriminate is also evident in the case of employment assessments. Assessments became commonplace in the years following World War II as the field of organizational psychology grew and as the post-war period ushered in an economic boom. So multiple choice assessments that once were completed with number 2 pencils on Scantron now look more like video games than they did the SATs. These assessments are proving very valuable to high-yield, high-turnover employers, and they have the potential to minimize bias in hiring by shifting the employer's focus from a resume to aptitudes and attributes. But at the same time, they are as vulnerable to disparate impact claims as the Scantron sheets is old, so employers must use them with equal diligence. After all, the Supreme Court decision that created the disparate impact analysis I explained earlier, Griggs versus Duke Power, turned on the disproportionate adverse effect that a company's standardized test had on African-American employees. Additionally, online assessments present a novel challenge to people with disabilities because of the generalized interface they employ. So for vendors and users of AI, the closest thing to guidance on how to test for discrimination is found in the EEOC's 1978 Uniform Guidelines on Employee Selection Procedures. To that end, that guideline offers a technique through which to test for disparate impact known as the 4/5 rule. But the 4/5 rule is not a universally applicable formula that proves whether or not a selection practice is discriminatory in all cases. It's just one of many ways to test for disparate impact. So there's no absolute and unfailing formula to prove disparate impact discrimination. That's why employers who are thinking about buying AI technology should press vendors for details about how they go about testing for disparate impact discrimination and what testing they do. So all this to say that employers should do their due diligence when it comes to vetting AI. Workplace discrimination imposes heavy human, social, and financial costs. But employees, you're not alone as you navigate the promise and perils of AI. I'm here to help support all of you in that undertaking. The EEOC is a law enforcement agency, but I believe that enforcement alone will never be sufficient to achieve our mission. I believe that preventing employment discrimination from occurring in the first place is much better than remedying its consequences. It has been my experience that most employers want to do the right thing, they just need the tools to comply. So especially when it comes to the AI vendors, they believe in their algorithms and their ability to promote the equality of opportunity in the workplace, and they're seeking guidance in order to ensure that this program works. And I think we should all welcome this interest. So I've covered a lot of ground. I very much look forward to your questions, and I hope this was a very helpful overview in the way that some of the technologies are currently being used.
Thank you, Commissioner. That was a fascinating overview, not only of the background of disparate treatment, but also, how prevalent AI is in becoming in the workplace. I mean, just to your point, it's covering every facet of the hiring process, from recruiting to screening to, evaluations to promotions, and even maybe performance issues. So thank you for that overview. You did talk at one point earlier about the importance of an employer's oversight when being subjected to AI technologies to ensure that workers are treated equally. But what happens if an employer doesn't have that human intervention? What are some potential issues with AI when there's no human involvement or intervention at that point?
Yeah, and this is really important to remember now that companies, as you just said, it's more than just recruiting, it's more than just hiring. Now companies are turning managerial functions over to AI, and we've seen news reports about how the employees' only interaction are with a chatbot or AI, basically governing all their employment. So this really highlights the challenges of finding the right division of labor between algorithms and HR personnel, between using AI to improve human decision making and delegating it completely to algorithms. So using AI to make decisions ordinarily made by HR professionals can have significant legal ramifications. There may be cases in which compliance with the federal anti-discrimination laws requires human intervention. So this is frequently the case when it comes to workplace accommodations for pregnant, disabled, and religious employees. Generally, these accommodations are granted through what's known as the interactive process between the employer and employee. And, in the past, that's done by two humans. So most of the time, the employees initiate the interactive process by notifying their employer of the need for a reasonable accommodation, a conversation that can be personal, sensitive, and even difficult for employees. If the employees primarily interface with their employer as an app or in a chatbot, initiating that process may be daunting. Employees may not be willing to disclose some of their most personal and protected issues to a chatbot. For that matter, it may not even be clear who the point of contact is for that employee. So a lot of times too, people are surprised to know that there's instances where the employer is expected to initiate that interactive process without being asked. So for example, if the employer knows that an employee is experiencing workplace problems because of a disability, under those circumstances, the process often starts when a supervisor senses, again, with their own eyes, their own human judgment, that the employee is struggling. So an algorithm, no matter how sophisticated, may not be capable of that sort of sensitivity and responsiveness needed to meet the needs of employees who needed accommodation. So this means that humans, especially when it comes to the disability accommodation, religious accommodation, pregnancy accommodations, must remain in the decision-making process, because whether employers rely on algorithms or HR professionals or both, they must develop and implement policies to handle these requests for reasonable accommodations. And this is, especially true as we're seeing employers using AI to do performance and tracking productivity. Employers should always ensure that the AI system allows and accounts for reasonable accommodations. And they must inform their employees that the requirements to engage in the interactive process for an accommodation under ADA or Title VII still applies when they're using AI. So I really think that's an area, as we'll talk about more, that human needs to stay in the loop by law.
Thank you. Jordan, do you have a question?
Sure. Commissioner, back in October 2021, the EEOC announced that it was launching an initiative focused on fairness in the use of AI and algorithmic tools. What can you tell us about what that initiative is doing right now, and what we can expect to see out of the EEOC going forward?
Sure. So in October of last year, we formally announced an initiative on the use of AI in the workplace. So the initiative is going to examine more closely how basically everything we just discussed, how technology is fundamentally changing the way employment decisions are made. It aims to guide applicants, employees, employers, and technology vendors, ensuring that these technologies are used fairly and consistent with federal equal employment opportunity laws. So as part of the new initiative, EEOC plans to establish an internal work group to coordinate the agency's work, launch a series of listening sessions. We've had one that you could see on YouTube related to with disability stakeholders, disability advocates, gather information about the adoption, design, and impact of hiring, identify promising practices, and issue technical assistance regarding AI in employment decisions.
And even more recently, Commissioner, just last month, I think the Commission released its first technical assistance guidance on AI. Can you tell us a little bit about that guidance, what it says, and really what are some of those promising practices outlined in the guidance?
Yeah, so just last month, we released a technical assistance document titled The Americans with Disability Act and the Use of Software, Algorithms, and Artificial Intelligence to Assess Job Applicants and Employees. We did it on the same day that Department of Justice, in coordination with the Civil Rights Division there, also released some guidance on the ADA and technology. So this document really focuses on preventing discrimination against job seekers and employees with disabilities as related to artificial intelligence. It provides practical tips to employers on how to comply with the ADA, as well as tips for job applicants and employees who believe their rights may have been violated. So the guidance highlights 3 common ways that employers' use of AI can violate the ADA. The first is if employer does not provide a reasonable accommodation that's necessary for a job applicant or employee to be rated fairly and accurately by the algorithm. The second, if the employee relies on an algorithm decision-making tool that intentionally or unintentionally screens out an individual with a disability, even though that individual is able to do the job with a reasonable accommodation. And if the employer adopts an AI tool for the use of related to applicants or employees that violates the ADA with restrictions on disability related inquiries and medical examinations. So the guidance reminds employers that they may be responsible under the ADA if their AI tools, even the tools that are designed or administrated by another entity, such as the software vendor, don't account for those disabilities. But as you said, we did give some promising practices in there, as we call it. So those promising practices, as a preview, because I want you to actually look at the document, employers might consider asking whether a vendor has made a user interface accessible to as many individuals with disabilities as possible, whether the materials are presented to job applicants or employees in alternative formats. So if so, like what are those alternative formats, and whether the vendor determined if any of the characteristics the tool measures are correlated with certain disabilities. More promising practices include employers are encouraged to train staff to recognize and process requests for reasonable accommodation as quickly as possible when relating to this technology. And it encourages employers to use AI tools that have been designed to be accessible for individuals with as many different kinds of disabilities as possible.
Perfect. Commissioner, I believe there are other state and local regulatory efforts in this area happening as well. So what do all of these overlapping efforts mean for employers who are trying to actually comply with the law?
Sure. So there's not as related to AI, there's not a federal standard yet. So we've seen state and municipal legislators begin to address some of the legal issues that I was discussing today. So on one hand, local and state governments should be commended for taking up a very complicated issue of algorithmic bias in employment. But at the same time, they risk creating a patchwork of conflicting laws that create more confusion than clarity for employers who are operating on a national level. So again, it underscores the need for the federal government to be doing more. So the first really law we saw was in Illinois in 2020. That was the Artificial Intelligence Video Act. And that required employers to notify applicants in writing prior to a job interview that AI may be used to analyze applicants' facial expressions and consider the applicant's fitness for the position. It requires employers to provide applicants with information explaining how their AI works, what general types of characteristic it uses to evaluate applicants, and the applicants actually must provide written consent before being subject to such an interview that uses that facial recognition technology. We saw in Maryland as well in 2020, they amended its labor code to address facial recognition services during a job interview. And basically the law prohibits employers from using facial recognition during a job interview without the applicant's consent. More broadly in California, we're seeing there's a bill the state legislator is looking at related to it's called the Automated Decision Systems Accountability Act. So that would create disclosure and accountability requirements for government contractors who use AI in the decision-making process that affects legal rights, health, or economic interests of a natural person. There, they would have to do an impact assessment and disclose it. We're seeing that there's potential revisions to the California labor code by their labor department related to having potentially vendors be liable as well. So a lot of proposals as well, but the one that actually has passed that is more broadly than just some of the video laws we talked about is in New York. And, that's New York City. They have their automated employment decisions tools, which will regulate the use of automated employment decisions in hiring and promotions. That bill takes effect January of 2023. So it broadly defines AI tools in any system that uses algorithmic methods to screen candidates for employment or employees for promotion, but then limits it to who live in New York City. So basically it prohibits employers from using these tools unless the tool underwent a bias audit and the employer publicly included a summary of results of the audit on its website. And it would require employers to audit their AI hiring tools, not only on the basis of race, ethnicity, and sex, and not on the basis of other protected characteristics such as disability or age. And so before using the tool, it would have to give the employees a lot of notice and rights, and the employee would be able to opt out of that. And something similar as well in Washington, D.C. by the Attorney General here. also has a bill proposing if AI is going to be used, it needs to have significant audits as well. So we're really, those are just some examples we're starting to see about local and state governments starting to dive into this issue. But from our perspective here at the EEOC, Illinois, Maryland are dealing with the facial recognition. New York is limiting their categories of what the bias audit is. We don't have that luxury. We have to look at every, under federal law, look at every way that artificial intelligence impacts the employment relationship. So, but there are states looking at very certain specific areas.
Commissioner, I have one final question that I want to pose before we open it up to the audience. So those of you, if you have a question for Commissioner Sonderling, please put it into the chat function, and we'll try and get to as many of those questions as we can. But just, my final question to you is going from, Jordan's question of local efforts to really international and global efforts. You've been speaking recently a lot at some international forums. And so I'm interested to hear how you think these global efforts will influence what the EEOC and what other people are doing here in the United States.
Yeah, so really, as we've seen the Europe, the EU starting getting more aggressive with some of the regulations when it comes to technology, and they have what's called the European Union's Artificial Intelligence Act. So this would be a risk-based approach to regulation of AI. And it creates a 4-level taxonomy of risk from unacceptable to minimal. So they've said in their proposal that AI systems used for employment purposes are characterized as high risk alongside with biometric identification, critical infrastructure, and dispatch of emergency services. So these high-risk systems are subject to very robust reporting, disclosure, validation, and accuracy requirements. But the most notable part of this proposal is that it covers providers of AI systems. That is, the entities that develop the systems and place it on the market, or that develop the system and put it for use for themselves. So that's quite different from the state of affairs here in the United States, where the employers, not the vendors, are usually on the hook for employment discrimination.
Okay, let's see if anybody's posted a question in the chat. I see one so far that's come in, particularly as it relates to the COVID pandemic. Would it be unlawful to use AI to screen out unvaccinated applicants? How do you think employers should navigate that process if they have a vaccine mandate in their workplace?
Well, this is a little different question here. Relating more to COVID vaccinations. The EEOC has taken a position related to COVID vaccinations that, the employer, if they want to have a mandatory vaccination policy, the law allows that, that's fine. And this is obviously, putting aside any state and local laws or everything related to OSHA. So if an employer wants to have a mandatory vaccination policy where they only want to hire or retain those who are vaccinated, that's fine. However, our laws require that there has to be some sort of reasonable accommodation related to the people who can't get the vaccine for one of 3 reasons, whether it's a disability, pregnancy, and the most hotly contested one is related to a religious exemption to the vaccine. So to answer your question related to AI, if AI is being used to screen out applicants who are not vaccinated, it's not that simple. You need to know the reason why they're not vaccinated. And if you can make a reasonable accommodation related to them, if it relates to a pregnancy, a disability, or a religious claim. If it's just screening out, people who don't want to be vaccinated for political or social purposes, that's one thing, but it would be very difficult just on the blank sense to use AI and say, we don't want any people who are not vaccinated. If they say no, well, the EEOC requires that next step saying, well, is it because of one of those 3 categories? And then at that point, the employer has the obligation to make a reasonable accommodation if necessary. So a little more complicated than just a yes or no. It really has to, yes, you can screen out unvaccinated workers if you have a mandatory vaccination policy, but you still have to accommodate those who can't get the vaccine. And maybe a little difficult to know that if you're just blanket using AI to eliminate them.
Yeah, I think that would be one of those areas where human intervention and oversight would absolutely be required if you're going to use AI in that particular area. Thank you. Let's see. Another question has come in. What red flag should HR professionals that are overseeing AI hiring tools look out for to minimize discrimination?
So, a lot of it is, like I said earlier, whether it's a discriminatory data set or it's a discriminatory algorithm, and I gave you examples of both, when you're, only have certain people in the data set versus having an algorithm that you can go in and actually filter out people. Look, we're going to look at the results. The EEOC is going to look at the results. Does the results show discrimination? If it does, then we'll backtrack how we got there. Now, was it intentional or was it based on the data set? So the most important, piece of advice I can give here is how did you get to that discrimination? Was it because of a algorithm you can fix, or limiting the characteristics of what goes into that algorithm? Or was it the data set of not having a diverse applicant pool? Or, how did we get to the decision making to there? So, but for the EEOC, we're going to look at the results. And for you as HR professionals, it's really important to look at the context of the facts and look to your own data sets to see how those results came.
Thank you. Another one. Since Title VII and other federal employment laws already cover disparate impact claims, which could be used against discriminatory AI impacts, what do you think would be the added benefit of an AI-centered federal employment law?
Well, like I said, I think, our laws may be old, but they're not outdated. I don't think we need, any new laws here. And I think, there's a distraction when you're talking about, especially in our space. Look, these are some of the strongest civil rights protections created in the 1960s out there. And I think our laws cover every type of discrimination possible by artificial intelligence. It's just on us as the EEOC to break it down, as we most recently did in the ADA guidance, on how it applies to this new technology. So, as I said, whether it's how we got there, whether it's intentional discrimination by tinkering with an algorithm, excluding people, or it's that unintentional discrimination based upon only looking at certain classifications of individuals in your applicant pool or data set, liability is going to be the same. And that hasn't changed since the 1960s. It's just now we're talking about potentially scaling discrimination on a much more significant basis.
We talked a lot about, employers and what HR practitioners can be doing, but what about a job applicant? How can a job applicant understand or ensure that if they are using, if their company is using a resume screener or some other screening tools, that they are being assessed fairly by those tools?
So this is what some states are trying to, excuse me, this is what some states are trying to address. And this is what you're seeing in the New York proposal and in Illinois when it comes to facial recognition, is that consent that, we're telling you we're using artificial intelligence during your interview. Now that's not a federal standard, but when it comes to, our recent guidance related to the ADA, that is, there needs to be accommodations in place. So if somebody, can't do the automated interview because of a disability, the applicant, just like in any other sort of employee testing, needs to tell the employer, and the employer has to make an accommodation, has to give them an equivalent test that doesn't involve, potentially the AI or computer decision-making, just like anything else related to disability accommodation. So that's a tricky area right now because, you may not even know that a human never saw your resume, or that you're not interviewed by the results of what you're submitting is never going to be seen by a person. And, that's more on the disclosure requirements that from a federal standard, it's, there's nothing related to that yet, but some states are trying to tackle that.
Do you think that the states could potentially model that, add a federal guidance? I'm thinking when you think about consent, kind of very similar to the Fair Credit Reporting Act, where if a company is going to use a third-party vendor to check criminal background checks, that they have to notify applicants of that in advance and get their written consent. Do you think that could be an area of federal employment statutory, creation of that type of consent? and
Yeah,
advance notice.
Yeah, I don't know if it's going to happen. That would require amending the laws, and there's a lot of other things people would like to amend our laws to do. But for the time being, it's really, it's a difficult position for employees to be on. That's why the more awareness we raise of this, the employees know their employer's obligation when it comes to using AI during testing, specifically related, as we did recently, related to the Americans with Disability Act.
Kara, I have one or two more questions that have come in. Commissioner Sonderling, you mentioned that AI that scrapes publicly available data like LinkedIn for diverse candidates to invite them to apply for jobs has the potential to create disparate impact if certain individuals are not even aware of the opportunity to apply for that job. How is this different than traditional affirmative action efforts to use targeted outreach to minority groups to advertise jobs? And is this any different if AI scrapes LinkedIn versus human recruiters search LinkedIn for candidates?
Yeah, no, I mean, the employer is liable for, the decisions made, whether it's coming through these online resources or it's by a human recruiter. And, it gets even more complicated for those of you who are on the call who are federal contractors who have that affirmative action obligation where you need to do targeted recruiting and you need to diversify your work pool where, under the executive orders there, that's what you have to do. But, at the end of the day, whether the applicant pool, is diverse or not, is going to be, obviously very specific to the type of job and, where you're doing the recruiting. But, if there is disparate impact and because of, a data set that wasn't complete, that those actions weren't doing, the employer is going to be liable. So whether it's scraping publicly available data, where that gets tricky is that, if you're looking for the ideal candidate and the ideal candidate has the characteristics of a stereotype characteristics, like in the coding world, because the vast majority of, the statistics related to coders happens to be men, if you're using LinkedIn to look at coders and it's just, you're only looking at men and that's your applicant pool there, it's obviously going to have a disparate impact on women. So it's a very complicated analysis. What I'm trying to raise awareness of here is that it's no different than, using recruiters before. It's just now using this technology, you could scale it much larger and discrimination could just become so much bigger, so much faster than any one individual person can do.
Understood. One final question that came into me. How could an employer's use of algorithmic decision-making tools potentially violate ADA restrictions on disability-related inquiries and medical examinations?
Yeah, our new guidance discusses that and goes over that in pretty strong detail because, if you're using these just standardized tests, and the standardized tests don't have any job relatedness, and if it's inquiring and potentially elicits some medical information or disability related inquiry that is not relevant to the job, but it's just a standardized test, now you can, you potentially, even people without disabilities, if you're asking for medical related claims because of a standardized program, it may violate the ADA. Pretty significantly, but our new guidance goes over this very specifically. I encourage you to read it because we talk about how to be careful when it comes to medical related inquiries and using artificial intelligence.
Thanks, Commissioner. I'll leave it back to you just to close in the last few minutes of any final thoughts, any takeaways for the group. And then just as a reminder to everybody, this is being recorded. We will circulate the recording to everybody who participated, and we'll also circulate a link to the technical guidance that the Commissioner mentioned so that everybody has it at their fingertips. But in the meantime, this has been a fantastic program. Thank you, Commissioner, for your time today and your excellent insight and raising this important issue. And I welcome to hear your final thoughts.
Yeah, so I've only given you a few examples of the ways companies are using AI to make employment decisions. But the bottom line is, and I've repeated this, throughout my presentation, is that employers just cannot adopt a hands-off approach to HR technologies because inaccurate, incomplete, or unrepresentative data will only amplify rather than minimize bias in decision making. So again, whatever the algorithm is, whatever the decisions, employers need to be vigilant against two things. One, that's discriminatory uses and discriminatory outcomes, because liability is the same either way. So we can all really not realize the potential of AI unless it is developed and utilized in a manner consistent with our laws and values. Again, the EEOC and we stand ready to help our innovators, employers do precisely that. And again, I encourage you to become partners with us in this worthy enterprise. You're the ones out there being sold these products. You're the ones interested in buying it. So share your concerns and let us know how we can help ensure that AI helps promote inclusion and helps minimize discrimination in the workplace. Because the key takeaway from all this is that although AI is becoming mainstream technology in the workplace, discrimination by algorithm cannot, and that's something we should all really strive to prevent.
Excellent. Great. Well, thank you again. And with that, we will close at the hour. And thank you again for your time. And I hope everybody enjoyed the terrific presentation.
Thank you.